Hello, everybody. I'm Dwania, and welcome to our Ask the Expert segment. This is the legal edition, and this is part two. So, if you did not catch part one, you want to go back and watch part one. I'll put the link in the video description. This segment is brought to you by Goodlawyer. They are a Canada-wide network of lawyers that cover all of your business needs, from corporate compliance and commercial contracts to patents and trademark. Goodlawyer is your one-stop legal solution for founders. To find out more, click the link in the description to learn about their service as well as to claim $100 in Goodlawyer credits, plus your choice of a free 15-minute legal advice session or $50 off a contract review. Our special guest today, who's going to answer all your legal questions, is Pauline Chan. She has over a decade of legal experience helping businesses of all sizes, from sole proprietors to multinational corporations. She also has experience owning and running her own bar fitness studio, giving her firsthand experience of what it takes to help your business succeed. Now, before we jump in and before we get Pauline to say hi, remember to like, share, and subscribe to the channel so that you don't miss out on what we have coming up. Welcome, Pauline.
Thanks, Dwania. Hi, everyone. My name is Pauline. I am a lawyer practicing on the Goodlawyer platform, and I'm also lawyer in residence for Goodlawyer, where I help them improve the access to law for founders like yourselves, and also for lawyers who don't necessarily have access to the profession. I'm super excited to be here today. Thanks for having me.
All right, let's dive right into the questions. Now, before we talked a lot about, what business lawyers do, what is business law, why should you even hire a business lawyer as a small business, and how do you protect your ideas? Again, if you didn't catch that segment, make sure you jump over and give it a watch. First question for today. Why is it important to have a lawyer review all contracts?
Well, so this is something that of course, I've always thought it's very important because there is risk with any business activity that you undertake. You want to do your best to be able to protect yourself and your business from that risk. The more important thing I think that is often missed by a lot of founders is when you have somebody review the contracts that you're looking at, whatever it may be, your lawyer is also going to be able to help you find different areas where you can make essentially a better deal and improve the quality of your relationship with whoever the other party is on a contract. So in the employment law area, I would say one of the examples is when you have a written employment agreement with your employee, you're making a better deal simply by having everything out on paper so that it's clear for you what you are offering this employee or contractor, what they are expected to do for you in return, and how the mechanics of that process will work. How does payment work? If you're a contractor, is there any sort of expenses they might incur that you might be willing to pay for as the other contracting party? If we're talking about in a commercial business sphere, sort of something to the effect of your payment processor, something that I brought up in our previous discussion. These contracts come to you, and a lot of founders, I find, will say, okay, sure, whatever. They sign and they send it back. When you are looking at these contracts, this is what the deal is between you and whoever the other party is. There is always room to negotiate. There is always room to determine if this contract as it stands is going to work for the actual processes in your business, or the whatever it may be, payment terms, or maybe it's how the actual exchange of information happens, whatever it may be. You want to be able to understand what that deal is before you get into the relationship. You also want to know if it's going to work for your business. If they are asking for specific processes that they need you to perform to in the contract, but you look at your business and you think, well, that's not really going to work because this is how we collect money, or this is how we this is how we send out products to our customers. But this is the process that your vendor is saying that you need to follow. If those two are not matching up and they're sort of at cross purposes, you need to understand that before you sign it and agree to it. It's always better. You always need to read that contract on one side for the business aspect of it, but you also need an expert, a lawyer who's going to read it and say, from the legal side, this is maybe not the best way to approach this. Here's some laws, here's some case law that actually applies to this specific situation. And this is how I can help protect you against that situation from happening. Or simply, I don't know if this is going to match with your business because this is what they require on their side. This is what your business does. These two don't match. How can we rejig the language in this contract to make sure that it works in your favor, but also works out for the other party so that they are willing to come to the table and sign the contract?
Yeah, and a lot of times as small business owners, we don't think we have the ability to contest anything that might be in a contract. I mean, it's terms and conditions. You can definitely ask questions and see what works for both parties.
Absolutely. Yeah. And I will always say, there's no harm in asking. I mean, you may think that you don't have any power to negotiate, but what's the harm in asking? The worst that will happen is they will say no. And then you have to decide whether you're going to move ahead with this contract or not. How important is that thing? It's very much to me an exercise of looking through your contract, understanding what the most important things are to you, and then whether you need to negotiate those things or not. If it's all okay with you, that's fine. You can sign it and send it off. But without having gone through that exercise of actually thinking about what's important to you, and then also understanding on the legal side, what is the risk? How does this help build your business? How does this help grow your business? Without understanding all of those things together before signing and agreeing to something, I think unfortunately puts you in the circumstance of learning by trial by fire, trial and error. And while that is acceptable for a founder and even, something you want in certain cases, in other cases, it's best to not have to learn by being in that situation, right?
Yeah, other people went through this so that you can, take from their experience.
Exactly. Yeah, exactly.
Okay. So about contracts then, because we do have to review them, what are some of the key items that should be reviewed in all contracts?
So always, I think the top one I'm going to say is the parties. This sounds really ridiculous, but it is not from a legal perspective. I run into a lot of contracts where the parties have been misidentified. So, for example, you, Dwaynia, you sign a contract. You have a business ABC Limited. When you're contracting with somebody, though, they enter your name, Dwaynia, as the party to the contract. And you say, okay, everything looks good. That's my name. And then you read through the rest. Everything's fine with you. And you sign and send it off. Unfortunately, that contract is now between the other party and you, Dwaynia, personally. It's not actually a contract with your corporation, which means you've actually taken on the risk, all of the risks and liabilities and rights that you need to perform are you, Dwaynia, the person, not ABC Limited, your company. So that's one really important thing you're always needing to review and make sure that's properly set out. It's the same with the other party, making sure that you know who you're doing business with. Is it a person or is it an entity? And then you understand potentially who is performing the contract and who is liable if anything should go wrong. Another area, these are more the business terms, I would say. You want to be sure you're looking at what is the scope of the arrangement? Who is doing what? Who is responsible for doing what? Who is responsible for doing it when? What those deadlines and timelines are? Are they flexible? Are they not? And then you're looking at perhaps what those payment obligations are. How does that work? When do you get paid? What does payment look like? Is it 10 days upon invoice receipt? What does that invoice need to look like? Is it just any old invoice or does it have to follow a specific format? All of those sort of mechanics and details around payment and pricing. And then on the legal side, I'm always going to say warranties. What are you, as the service or product provider, for example, what are your warranties? What are you guaranteeing? If it's nothing, are you saying that? Or if it is something, how long is that guarantee on for? Is it forever? Is it 3 months? Is it 2 days? Are there specific things that your customer has to do to take advantage of that? The second area, super, super important, highly, highly negotiated, is your liability and indemnities. So what are you liable for as the business for your product or for your service? What are you liable for? And what your indemnities, which is essentially if there is a liability, how are you going to reimburse the other side for that liability that has come to them? How are you going to reimburse them? Are they going to reimburse you? Do you reimburse them? Is it the same both ways, or is it one way? Only one person needs to do that for the other. What does that look like? These are all very heavily negotiated areas. The last thing I would say, warranties, liabilities, and then the sort of subset I would say is the exclusion of liabilities. So if there's anything that you are not liable for, no matter what. So depending on what you're offering as a product or a service, are there certain areas where you have zero liability? Are there certain areas where you will offer a little bit of liability? You will take on a little bit because, again, with every business, you have risk and reward. And how does that line up? How much risk are you willing to take on for the amount of reward that you are getting out of that contract?
Wow. Okay, so then we have all the contracts, right? But a lot of times there are these templates that are out there that on a lot of websites that you can use. Are legal or templated legal documents good for your business?
I would say they can be, but unfortunately, it's in a fairly limited situation. And it would be those situations where that template actually suits your business exactly the way you run your business and exactly your product or exactly your jurisdiction. So jurisdiction meaning where is your business located? Where are you doing business out of? If are you selling products across the country? Are you selling products in only one province in Canada, for example? The templates can be good, but they really need to suit your circumstances. And it is exactly what it is. It's a template. So it's a starting point. And so it's great to sort of have a starting point, but very, very often it's very rare that you'll be able to pull down a template that matches what you are doing exactly in your business. And if it doesn't match what you are doing in your business and the operational realities and the legal requirements of where you're doing business, then if it doesn't match, then it's sort of it's just another piece of paper. It doesn't really mean anything. And worse, it can actually create situations that where you are immediately not complying with your contract and immediately in a breach of your contract because it doesn't match the reality of what is happening in your business or where you are doing business, for example. So it's very common. I'll see a lot of contracts that people have pulled. And one of the first things that I'll notice is this is written kind of weird, and it really makes me think that this template came from an American site. If it came from an American site, you're doing business in Canada, they're similar. We're similar in terms of our systems of law, but not exact by any means. And now what is that contract doing? Is it actually protecting you? Maybe, maybe not, probably just maybe slightly, but it's more like it's instead of straight on like this, it's kind of tipped off to the side. So you're catching maybe one corner of protection, but it's really not relevant, perhaps. Or again, it says in the contract that you go through this certain process when you're collecting personal information. Well, are you doing that in your business? Because if you aren't, that process that's set out in the contract is not actually helping you. It's only creating requirements for you that you are not meeting. So now you are immediately in breach of contract against the other party in your contract. Is that a good position to be in? Not really.
Wow. Okay.
So
Noted.
it needs some tweaking. It'll need tweaking. It'll need some work. It'll need some thought, both on your side as the business owner, but also your lawyer who can say, this doesn't suit what you need. This is an American contract. It's not going to work for you. This is for the wrong province. They have different laws in relation to privacy, so it's not going to work, whatever the case may be.
So let's say you have a contract and it's not a template that you got and didn't make sure that it works for your business. You have a legitimate contract. If a party breached your contract, what would be the next steps?
So first thing, you're going to want to review the contract with or without the help of a lawyer, depending on what that contract looks like. The legal steps to resolving a breach of contract I'm always going to say to my clients, look at the contract. Let's look at it together. There's usually often provisions in contracts about what happens when there's been a default under the contract. So you didn't meet your obligations, whatever that obligation may be, then what are my remedies? What are my next steps? Sometimes contracts will talk about, there's going to be, say, a 10-day period where we may have discussions in good faith to try to resolve this dispute or this breach. Or maybe I'm going to say, I'm going to give you a notice of breach of contract or notice of default. And once I give you that notice, maybe the contract says you have 10 days or 30 days to figure out how you are going to remedy the situation. With it, and then after that, maybe you're not. After that, if you haven't fixed it, then I have the right to say, you know what, I'm ending the contract, I'm out, this is over. And then here's the termination section that talks about how you get out of the contract. And then you're going to look to the liability provisions about who may or may not be liable for which and or what. So you're always going to go back to the contract. If a party breaches it, you're always going to go back to the contract and look first to see what the provisions are that deal with these sorts of situations. The next thing I would say, though, is from a business side, the contract is there in a way as a backstop. That is the legal sort of what you can do if everything else fails. But practically speaking, depends on what's happening with the breach. If the other party, you still want to work with them, they breached it, you still want to work with them, now what? That's a business decision. You can then think about different sort of ways that you can solve the problem and deal with the situation and make it fair for everyone. You're sort of essentially you're negotiating something. You're negotiating a settlement of some sort of a claim situation. That's a business. That's the business part of it. If that fails, you can always turn back to the contract and say, okay, you know what? Our discussions were all for nothing. Now we're going to go back. I'm going to go back to the contract. Turns out my rights are I can go file a claim, or we still have to go through another 10 days of negotiations. And then maybe next we have to deal with and get an arbitrator involved, and we have to do some arbitration to figure out what the resolution is going to be. If that fails, then we go to the courts. So the contract gives you your backstop of what can happen if everything else fails. But you are always free to have those business discussions as to how we want to resolve this, because, I still want to work with you. I still want that relationship. I don't want to go to court, and neither do you. So let's just figure this out and move on.
Yeah, and especially if you want to work with them, maybe something changed in their business and they just cannot fulfill the needs of the contract. Then maybe a new contract is required because, hey, I can't fulfill these needs anymore.
Yeah, that's right. That's right.
Okay, wow. Well, we went through a lot of questions. This was like the contract edition. Thank you so much, Pauline. And everyone, remember, submit your legal questions in the comments or in the link in the description. And if you have financial, accounting, or grant-related questions, you can submit them in the link in the description as well. Also, like the video, subscribe to the channel, and let us know your thoughts on the segment. Special thank you to our segment sponsor, Goodlawyer. Click the link in the description to learn more. And thank you again to our expert, Pauline Chan. We'll see you in the next video. Bye.